Okay, this is time on the calendar of the Apache Junction Justice Court for a criminal bench trial, State of Arizona versus Shane Charles Aldrich. Let the record reflect. Counsel, I believe you're the prosecutor.
Yes, Your Honor. Charles Olson on behalf of the State of Arizona.
Are you Mr. Aldrich? Sir, step forward if you would, please, and have a seat there at the table so we can get you on the record. We'll let the record reflect then that we do have both parties present. Before we begin this trial, I'd like to pause for a brief moment of silence so that justice can be served here today. Okay, before we begin, I've got a couple of quick housekeeping matters. The court received several motions by the defense, Mr. Aldrich. In going through them, we had a motion to dismiss for lack of standing by the plaintiff, a motion for clarification, a motion for an evidentiary hearing regarding a constitutional issue about due process, and then a motion for sanctions. In reviewing those motions, first off, I do agree with the state's response that they are untimely filed, but on matters of this nature, I always read them very carefully just to make sure that we're being fair to everybody. And the one that attracted my attention was the motion for the evidentiary hearing because of the denial of due process. And then on that motion, the defendant's presentation, he's requesting an evidentiary hearing, but the pleadings, let me go back through and see what, there's a listing of documents that were not provided or information that was not provided, including officers' training records, the radio tape, discussing the time limits or the timetable involved in the original arrest. Have you had a chance, counsel, to read that motion?
Yes, Your Honor. However, the state has disclosed all evidence that's within its possession that is relevant to this matter. This motion was filed 14 days before trial in what I believe an attempt to delay. If it was timely, I could have attempted to get more records if he had requested it sooner. We had multiple pretrial conferences. I see no record during those pretrial conferences that evidence was requested.
Okay, now I have a very specific question for you, and that is, do you agree with the defendant that, for example, CAD records and timeline gaps, officer training records, concealed departmental policies? I'm not asking you if you agree to the evidentiary value. Do you agree that those items have not been provided to the defendant?
CAD records have been provided, Your Honor. Officer training records have not, but they were never requested, Your Honor.
Yeah.
If they had been, we would have sent them over.
Okay. Here's what I'm getting at. In essence, as I look through this, if I were to accept the defendant, Mr. Aldrich's presentation in that motion on its face, I would still not find a constitutional violation. Unless the state wants to dispute any of these, what I would do, I want to articulate, because first off, there is the timeliness issue. And Mr. Aldrich, do you understand the rules of procedure?
I'm trying to understand those, Your Honor.
Okay, basically the rules of procedure say you gotta provide all your motions prior to 20 days before the trial date. These were sent to the court more like 10 or 11 days before the trial date. And the purpose for that is to allow the other side the opportunity to respond so that the judge can hear both sides. There is the timeliness issue, but with this one in particular, which again is untimely, as I'm looking at it, what I'm seeing is even if the state agrees that, we didn't give him the training records and we didn't give him a copy of department policies, I'm not finding that amounts to a constitutional violation if I accept your motion on its face as factual evidence. And so what I would do basically is deny that on its motion. So I would accept this motion as evidence the defendant has presented, but would deny it on that evidence. I just want to make sure we're clear on the record. Do you understand that, counsel? Do you understand what I'm getting at?
Your Honor, I will just say that the officer, Trentafellis, is present. He is going to testify. He will be able to be cross-examined where any questions about his training and office policies can come out at that point, and I believe that's probably the more appropriate way to go about it, but we defer to the court.
Okay. Well, I'll tell you what we'll do then. As we go through the trial, if one of those issues comes up, Mr. Aldrich, I'll give you the opportunity to object and state your objection for the record. That way we're creating a clear record in the event that the defendant does not prevail and the matter goes to appeal. Okay?
Yes, Your Honor.
So, counsel, would you like to make, and Mr. Aldrich, you ever been to a trial?
No.
Let me tell you how they work. It's just like giving a speech in high school. First, they tell the parties tell the judge what they intend to tell them, and then they tell them, and then they tell them what they told them. That's opening statement. That's when you tell me what you're going to tell me. Your presentation of evidence, which is when you tell me. And then third is the closing argument. That's when you tell me what you told me. Now, you're the defendant. You're under no obligation to present any evidence. The state has the burden in a criminal trial. They have to prove you did it. You don't have to prove you didn't. So if you decide you don't want to present anything, that is absolutely your right. But I will invite both sides to make a brief opening statement, which is where you tell me what you're going to tell me. Counsel, do you have an opening statement, or you want to get right to the evidence?
Your Honor, the state waives its opening.
Okay. And Mr. Aldrich, do you want to make an opening statement, or would you rather wait until you've heard the state's case and before you present your own?
I have an opening statement prepared.
Okay, if you would, go ahead.
Okay. May it please the tribunal, my name is Shane Charles Aldrich. I am present here today as a living man, a sentient being, and not as a corporate fiction, person, or entity subject to this court's presumed jurisdiction. I am here in peace to settle any controversy honorably, but I do not consent to contract with this court, nor do I waive any inherent unalienable rights. I must state for the record that fundamental threshold issues in this matter remain unaddressed and unresolved, specifically my motion to dismiss for lack of jurisdiction filed on May 16th, 2025, and my notice of lack of standing by plaintiff and request for judicial notice filed on July 16th, 2025, have not been properly adjudicated. These motions challenge the very authority of this court to proceed in the state's legal capacity to bring this action against me. Without a definitive ruling on these matters, this tribunal lacks the foundational prerequisites to lawfully proceed to trial. Furthermore, my motion for a more definite statement, my motion for evidentiary hearing, and my motion to compel Brady disclosure, all filed on July 18th, 2025, have also gone unresponded. The failure to rule on these crucial motions constitutes a clear denial of my due process rights, depriving me of the opportunity to present evidence on jurisdiction and to receive potentially exculpatory information vital to any defense. These recent unresponded filings, which in the absence of a point-by-point rebuttal with lawful authority and a verified claim from a living man or woman, stand as truth on the record. These documents demonstrate that this tribunal lacks proper authority over me and that the state has failed to present a verified claim against a living man.
I'm going to object. This isn't an opening. This is just him continuing to try to argue his motions that have already been ruled on.
Okay, and I'll go ahead and overrule the objection and allow the defendant to make his record. Go ahead and continue if you would, sir.
Therefore, I formally object to these proceedings moving forward to trial. I demand immediate rulings on all my pending motions, as they are dispositive and must be resolved before any consideration of the alleged charges. Proceeding to trial under these circumstances would be an improper exercise of authority and a violation of my fundamental rights. I am prepared to address these jurisdictional and standing issues and to receive the required Brady disclosures, but I cannot and will not participate in a trial that has not established its lawful authority over me or the state's proper standing to prosecute. Let the record reflect my position clearly and unequivocally. I am here under protest without waiving any rights and solely to ensure that due process is afforded and that the tribunal operates within its lawful bounds. Is there a living man or woman here who can present a verified claim against me under oath and full commercial liability?
Okay, thank you. And for the record, I'm overruling the objections based on the factual circumstances presented specifically in the one on the constitutional due process based on the facts presented by the defendant as evidence. So with that, counsel, you want to call your first witness?
Yes, Your Honor. The state calls Deputy Trentafellis as their first witness.
Deputy, would you step forward to be sworn, please? Please raise your right hand. Do you solemnly swear the testimony you provide will be the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. And if you would, I don't know if the prosecutor's going to ask you, would you spell your last name for me, please?
Absolutely. It is T-R-E,
T-R,
E as in Edward, A-N-T as in Tom, A-F as in Frank, E-L-E-S as in Sam.
E-L-E-S?
Correct.
How do you pronounce that?
Trantafelis.
What's your first name?
Nick.
Mind if I call you Nick? I'm going to call you Deputy. That way we can...
It works.
I'll have to take your word for the spelling. Counsel, proceed.
And Your Honor, before I begin, Isabella Keene from the Pinal County Attorney's Office just sat down behind me. She is a victim advocate in this case, but she will not be testifying. Just
Okay.
So it's
You're
on
an
the record.
as an observer?
Just as an observer, Deputy Trinafellis is a victim, so our victim advocates come out.
Okay.
Deputy, can you introduce yourself for the record one more time?
Yes, my name is Nicholas Trantafelis, Deputy for the Pinal County Sheriff's Office.
And how long have you been in law enforcement?
11 years at this point.
And how long have you been with the Pinal County Attorney's Office? Pinal County Sheriff's Office?
A little over 2.5 years with Pinal County Sheriff's Office.
Can you just briefly walk us through your training and experience?
Yes, so I was a deputy sheriff in Wichita, Kansas for my first 8 years of service. I attended the Kansas State Law Enforcement Training Center, which is approximately 18 weeks long. Received training on everything from constitutional law, criminal law, traffic law, use of force, completed field training, completed 8 years in Kansas as a deputy. Came to Arizona and challenged the state of Arizona by testing, written test, physical fitness test, emergency vehicle operations test, firearms test, which I all passed to receive a certification as a police officer in the state of Arizona. And in my career, I have over 1,000 hours of continuing training in law enforcement matters.
And what is your current assignment?
I'm currently assigned to the patrol division.
Can you kind of briefly explain what patrol means?
Yes, so I operate in a fully marked police vehicle, and I respond primarily to calls for service, and I conduct traffic enforcement as well in my designated areas.
And what was your assignment in February of 2025?
I was on patrol.
And were you on duty on February 25th of 2025, around 5:40
Yes.
p.m.? And where were you patrolling at that time?
At that time, I was patrolling in the Gold Canyon area.
And did you initiate a stop around 5:44 p.m. that day?
Yes.
Can you describe the vehicle?
Can you repeat that? I'm
Can
sorry.
you describe the vehicle?
Yes, the vehicle I conducted a traffic stop on was a Kia Seltos.
And what color was that car?
I believe it was white.
And where did you initiate the stop?
The traffic stop was initiated in the intersection of Kings Ranch Road and U.S. Highway 60.
To the best of your knowledge, is that within the jurisdiction of this court?
Yes, it is.
And why did you stop the vehicle? Just briefly.
So I first came upon the vehicle on U.S. Highway 60 in the turn lane to turn north onto Kings Ranch Road. And as I was parked directly behind the vehicle, I observed a license plate on the back of the vehicle that had characteristics on it that said private property, U.S. DOT, some numbers, and based on my training and experience, I believed it to be a fictitious license plate.
And you said you stopped that vehicle?
Yes, I did.
And did you make contact with the driver?
Yes, I did.
And do you see the driver in court today?
Yes, I do.
Can you describe him?
Yes, he's sitting to my right wearing a blue shirt.
And what was the driver's name when you ID'd him?
Shane Aldridge.
Your Honor, will the record reflect that the witness identified the defendant?
So noted.
So let's start with the plate. Did you speak to the defendant after the stop?
Yes.
And did you ask him about the license plate?
Yes, I told him that was the reason for the traffic stop was the license plate.
And what was his response to you?
His response to me was that he did not need a valid state registration license plate on his vehicle because he was just traveling.
Is there any chance that this plate was mistakenly issued by the Arizona Department of Transportation in your training experience?
Based on my training experience, this is not a plate issued by the state of Arizona or any other state in the United States.
And did you take a picture of this license plate?
I did.
Your Honor, may I approach?
You may.
I'm handing this in Mark States Exhibit 1. Can you tell me what you're looking at?
Yes, this is a picture of the license plate on the back of the Kia that I took on scene.
And is that an accurate depiction of the photograph you took that day?
Yes.
Your Honor, the state moves to admit State's Exhibit 1.
Okay. Mr. Aldrich, do you have any objection to this photograph being admitted as State's Exhibit 1?
I do not.
Then we'll admit that as State's Exhibit number 1.
Did you run a registration check on the vehicle?
Yes, I did.
Did it come back registered?
Yes, it did.
But he was not displaying his Arizona license plate?
That's correct.
Did you eventually ask the defendant for his driver's license?
Yes, I did.
And did he give it to you?
No, he did not.
Did he say anything when you refused?
He had told me that he did not need a driver's license, chest as well.
Counsel, hang on 1 second. We want to make sure we're getting the record. We're showing that the recording has stopped. I'm sorry? Okay. All right, counsel, go ahead and proceed.
Okay. A couple questions. So sorry to make you repeat yourself, but what uniform were you wearing when you stopped the defendant?
I was wearing a standard patrol uniform, which depicts sheriff across my chest, and I have a badge on my chest as well that says deputy sheriff.
And were you driving a patrol car at the time?
Yes.
Is it a marked patrol car?
Fully marked patrol car, black and white, says Pinal County Sheriff across the sides.
And you had your red and blues on at the time?
Yes.
And did you give him an opportunity to comply?
Yes.
Was it more than one opportunity?
Yes.
Did he eventually resist?
Yes.
Can you kind of describe how he resisted?
Yes. I had him step out of the vehicle. I told him he was under arrest. He had told me no. I grabbed his arm to turn him around.
One moment.
Objection, Your Honor.
State your objection for the record, please.
It's untruthful.
Okay, I'll let you cover that on cross-examination. And let me clarify this also, Mr. Aldrich. Objecting doesn't mean that you disagree with what's being said. In essence, you object because you think something is not admissible. If it's something you don't agree with, that's why we have trials. So I'll let you address that in your cross-examination of the officer.
Thank you.
And counsel, you may continue.
You can continue, Deputy.
Sorry. So I told him he was under arrest. He had said no. I then grabbed his arm to turn him around away from me. He tensed his body and tried to pull away from me. I then had to push him into his vehicle and forcefully pull his hands behind his back and place him in handcuffs. During this time, I gave him repeated commands that he was under arrest and to put his hands behind his back, and he failed to do so.
And did he say no once or repeatedly?
He said no multiple times.
No further questions, Your Honor.
Okay. Mr. Aldridge, do you have any questions of the deputy? Questions only at this point.
Deputy, did you actually look up the number that was on that plate to see if it was a valid U.S. DOT number?
The numbers on the plate were run through the state of Arizona, but I do not have the ability to run U.S. DOT numbers through my dispatch or in my computer in my car.
Can you again tell me what that plate says on it?
It says U.S. DOT, private property, the number's 434-8149, not for commerce, transport, or hire.
And as an officer, do you have the ability to look up Department of Transportation numbers?
Not in my current capacity, I do not.
Do you know of the SAFER website for a company snapshot?
No.
Okay. All of that information is available
Is
there?
it time for questions, sir?
Excuse me.
Any other questions?
Excuse me there. No further questions at this time.
Redirect.
Was the defendant displaying a valid license plate?
No.
No further questions, Your Honor.
Okay, thanks, sir. May I have that exhibit, please? Any other witnesses from the state?
No, Your Honor, the state rests.
Okay. Now, Mr. Aldridge, this is your chance to present a defense should you decide to do so. You're not obligated to do so. In fact, your right here today is to remain silent. However, if you do choose to present evidence, you are subject to cross-examination by the county attorney. Do you understand all of that?
Comprehend, yes.
Okay. And would you like to proceed? Do you like to testify, or how do you want to proceed?
Not at this time, Your Honor.
Okay, very good. Then we'll entertain closing arguments.
Yes, Your Honor, this is a pretty straightforward case. You heard from one witness from the state, who is also the victim in this matter due to the resisting of arrest. Deputy Trenifellis testified he was patrolling around Gold Canyon. He observed a vehicle with a license plate that, based off his training and experience, was not a real license plate. Upon a vehicle check, he found out that the vehicle was registered, but he was not displaying the license plate that he should have been displaying at that time. We admitted State's Exhibit 1, which shows the fictitious license plate on the back of the vehicle. The statute requires that the defendant know that the license plate was fictitious. The fact that vehicle is registered shows the defendant knows that that is not the right license plate for the car. That is not the license plate ADOT sent to him after he registered that vehicle. Further, when he was stopped, he was asked to show his driver's license. 28-1595B makes it very clear that when you're asked to present your license, you have to. He may have tried to show an ID, but from the officer's testimony, that ID did not have the driver's full name, driver's date of birth, residence, brief physical address, or the driver's signature, which are requirements of a driver's license. And then finally, there's no doubt that the officer was clearly a deputy at the time. He was wearing a vest that said sheriff across the front, a badge on the front. He was driving a very clearly marked patrol vehicle with red and blues. The defendant stopped for him. He knew it was a deputy, and he resisted the lawful arrest. He said no repeatedly and did not comply, and as such, we believe the state's met its burden of all three charges, and you should find the defendant guilty today, Your Honor.
Okay. And Mr. Aldridge, a closing argument from your side.
I'd like to categorically state that I believe that most of the testimony from the officer is false. The timestamps that I received from the CAD reports show a very short time frame to the time of the stop to the initial arrest. Resisting.
Your Honor, I'm going to object.
Mr. Aldridge, let me explain how it goes. This is where you tell the judge what you told the judge. You didn't tell the court anything. You presented no evidence. Now what you're wanting to do is, in essence, testify by way of closing argument without giving the state the opportunity to cross-examine, which I will not permit. So if you watch those old episodes of Perry Mason, they'll call that arguing facts not in evidence. They're not in evidence, so the state is proper in objecting to your statement, so I'm going to sustain that objection and not allow you to argue facts that are not in evidence.
Okay. And I would just like to preserve for the record that I will be appealing this.
That's absolutely right. Anything further?
Nope, sir.
Okay, very good. Well, it's kind of interesting. I was kind of hoping to hear more about where this U.S.DOT private property plate came from, but clearly it's not an Arizona license plate, and the officer's testimony was that there is an Arizona license plate that goes to that vehicle. We just don't know where it was. Arizona state law does require that a person that's going to operate a vehicle on the highways in the state of Arizona, if you're an Arizona resident, you got to have an Arizona plate. If you're here in Apache Junction and you're from Minnesota, I reckon you could display a Minnesota plate. If you're a resident of another state, you can display a plate from that state. But I am unaware of any provision or any issuing authority on a license plate that says U.S.DOT private property, not for commerce, transport, or hire. So on count one of the fictitious license plates, Mr. Aldridge, I am going to find you guilty. On the second charge of the failing to provide proof of identification or a driver's license, once again, the statutes here in Arizona are very specific. If you have an Arizona license, then you have to show that. If you don't have an Arizona license with you, then you have to show some other form of identification, and the statute's very specific about what that identification has to have. The only evidence before this court is that the evidence that was provided did not contain the statutory requirement. So I'm going to find you guilty on the second charge. And then the third charge, and this happens all too frequently, once again, it's pretty clear based on your motions and your statements here today that you disagree not only with the officer's authority to stop you, but also to place you under arrest. That's understandable, but you're still required to go along peacefully and follow the officer's instructions, and you didn't do that. In essence, and it's spelled out very clearly in the statute about offering passive resistance. You can't do that. A lot of people stiffen up and make it hard for them to handcuff them, or they won't bend over to get in the car. And all of that amounts to resisting arrest under Arizona law. It's a provision that was added onto the law that calls that passive resistance, and you cannot do that. So I'm going to find you guilty on that one as well. Now, would the state like to be heard prior to sentencing?
Yes, Your Honor. Your Honor, the state would ask for fines for each of the three charges. Additionally, we often request these on cases like this because this is a simple traffic stop that escalated when it should never have had to. These are dangerous situations that could have gotten way out of control with the defendant's behavior. So we always try to recommend that the defendant be sent to at Pioneer Justice Court, we use Life Skills Link. It's an online class. They have an offender corrections course that kind of helps to prevent this from happening in the future is our hope. And so we would ask that the court sentence the defendant to that as well.
Okay. And Mr. Aldrich, would you like to be heard prior to me determining a sentence?
I don't know what I would actually say at this moment right now.
Okay. Well, first off, sir, I have to compliment you on how articulately you present your position, both in your courtroom presentation and also here in your pleadings to the court. I've had pleadings submitted to the court in text language, if you can imagine. Motion to continue. Kids today can't hardly spell their own name, let alone write a coherent and articulate motion like you've submitted to the court. But the one thing, I guess, that I could offer by way of additional information for you, I wish that I wish every kid in school were educated to the level that you are in terms of the content of the Constitution, the U.S. Constitution. It is the supreme law of the land, but it's not the only law of the land. I've got a brother-in-law who just screams and yells because I tend to feel like one of the basic principles on which this nation was founded was minimalist government. And he doesn't agree with that. But he can't explain to me the rationale then behind the 10th Amendment. And the 10th Amendment is the one that I kind of want to rest on, because basically what it says is anything that's not covered in this document goes to the states. And so there's nothing in statute or case law that prevents each state from administering comings and goings in the state. They do have the right to regulate traffic. They have the right to regulate licensing requirements. I remember at one time when I was a kid, Nevada didn't have a speed limit. I like driving in Nevada. No speed limit. But other states were different than that. And that's one of the cool things about our U.S. Constitution is it allows the states to go off pretty much in their own directions. But it doesn't mean that, okay, the only law that governs me is the U.S. Constitution. There might be states that have less in the way of regulation of people's comings and goings in Arizona. I know there are some that have a lot more, but that's the one thing that I would encourage you to do is kind of wrap your mind around the U.S. Constitution is here, and it is the supreme law of the land, but not the only one. And if you focus on that 10th Amendment, that will guide you to all this other stuff where the state of Arizona is exercising their right as a sovereign of the 50 states. So with that, what I'm going to do on each charge is assess a fine in the amount of $250. So it'll be a total of $750, and that will include surcharges. And then if you'll step up here, a senior will help you further and tell you what you need to do from here. And counsel, thank you all very much. Deputy, I would tell you I'm going to work on the pronunciation of your name, but I'm just a pro tem. If I see you again, I'll probably call you deputy. All right. Y'all have a good day. Thank you very much.
Thank you, Your Honor.
Thank you.